Hello and welcome to 60 Seconds with Sergio. I am your host, Sergio Cabanas, attorney at law here in Florida. Thank you for joining me today. Today's question is really interesting. Sergio, I have a pending immigration application based on my current marriage with my spouse, who is a U.S. citizen or a U.S. permanent resident. However, I just received this denial letter from immigration officials claiming that my previous divorce from my previous wife, which was done in a foreign country, is somehow invalid, and therefore my current marriage is not legally valid either. What does this mean and what can I do? Let me clarify that question with this scenario or this example. Say you and your spouse were married in your native Colombia. You were both born and raised there and you married there. You then subsequently moved to different countries. You moved to the U.S., your spouse may have moved to the U.S. or some other foreign country out of Colombia. Now you both decide to get a divorce. You then hire an attorney in Colombia who processes the whole divorce, even goes as far as filing a divorce with a final judgment in Colombia. Then you remarry your current spouse in the U.S., and based on that marriage, you submit an application requesting legal status in the U.S. based on that marriage. Now you receive this nasty denial letter from immigration officials claiming that your current marriage is not valid due to the fact that your previous divorce in Colombia was not legally recognized here in the U.S. Well, what does that mean exactly, and what can you do about it? Well, what that means is that U.S. immigration officials are applying U.S. law. In this case, say you're in Florida, they apply Florida law to determine whether or not your previous divorce in Colombia was valid. Florida law requires that at least one of the parties be residing within the state of Florida in order to obtain a valid divorce. Remember, in my example, neither one of you were residing in Colombia at the time of the divorce in Colombia. Even though it does seem to make logical, perfect sense to get a divorce in the same country where you all were married, and you assume that's legal, for U.S. immigration purposes, applying U.S. law, it is not considered legal. So, now that you are not considered to have been divorced, that means that your current marriage is not legal, and immigration officials have no other choice but to deny your application based on the fact that you're not legally married to your current U.S. spouse. So now that we know what the problem is, here's a solution. The solution is obtaining a divorce in whatever state you reside in. In Florida, it can be done fairly quickly and easily, especially when both spouses can be found and both spouses are agreeable to having an uncontested divorce. We can process the divorce within a few weeks, especially if both spouses agree. Once you obtain your legal divorce through a final judgment in the state where you reside, you are now free to remarry your spouse and submit a new immigration application based on that marriage. That takes away the problem that immigration officials are having, and you're free to proceed with your new application. So of course, when you go get your divorce the second time around, you should hire an attorney. There's no room for mistakes, and time is of the essence. Don't do it alone. Get a knowledgeable attorney to get that divorce done for you so that you can submit a legal, valid application and get past all these problems so you can move on with your life. I hope this video provided you some general guidance over a complicated area of the law. Thank you again for joining me, and as always, stay informed so you can stay strong.